Fifth District of the State of Florida is now in session. The Honorable Eric J. Eismacher, Judge, presiding. All persons having business before the court should all hear and give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning. Welcome to an oral argument session of the 5th District Court of Appeal. Please make sure, whether you're at council table or in the gallery, make sure to turn off your cell phones or silence them so that we don't interrupt the advocates today. To my left here is Judge Strobridge from Orange County, and to my right is Judge Harris. And first up, we have 18-234, LEVIN versus the State of Florida. And counsel for the appellant, if you could just let me know how much time you'd like in rebuttal. I will attempt to work the clock here for you. And normally we give 5 minutes, but it's entirely up to you. So whenever you're ready.
Good morning. May it please the court. My name is Michael Ufferman, and I represent the appellant.
5 minutes for rebuttal, or?
Yes, Your Honor. I would like to reserve 5 minutes of my time for rebuttal. There's several claims raised in the briefs, and I'm hoping to address many of them during this oral argument, but let me begin with Claim 2, and that is whether the trial court erred in overruling the objection to Deputy Miller's testimony that the field sobriety exercises were scientifically reliable. Now, during the trial, Deputy Miller testified that he asked my client...
So how was it not invited?
Because,
or open the door, right? How? Explain that to me.
To answer that, let me begin by reading exactly what was said, and it begins on page 293 and 294 of the trial transcripts.
Because he didn't really say they're scientifically reliable. That wasn't his quote, was it?
He said they are scientifically proven, was his exact word. So just by a little bit of background, the deputy testified that he had administered 3 field sobriety exercises in this case: the one-leg stand, the finger to nose, and the walk and turn. And the record shows that my client did very well on the finger to nose, but the deputy testified that my client did not do very well on the other 2, the one-leg stand and the walk and turn. The record obviously shows that my client had just been in an accident, and more importantly, she was complaining that she was feeling numbness
in the legs.
In her
Sure.
legs. So defense counsel was cross-examining the deputy about why he didn't perform other non-intrusive, non-physical type...
Given the complaint that her legs were numb.
Correct. So this is page 293, 294. Question, and he could have also done the Romberg balance exercise, for example. Answer, yeah. Question, but you decided not to do that. Answer, no, I did not. No, I did the 3, and that's it. Question, you decided to arrest her at that point instead. Answer, yes. The walk and turn and one-leg stand are scientifically proven. I think there's like 80%, and then there's an objection, move to strike, and the judge overrules that. So you asked, is that invited? I say, in no way was that invited. Defense counsel is simply asking, why didn't you perform other non-intrusive exercises? And this deputy on his own decides...
And how was his answer not an answer to that question?
Well,
It might not have been the answer that your client wanted. But how is it not an answer to the question asked?
Because the question is, why didn't you perform other non-intrusive exercises? She's feeling numbness in her leg.
And he says, because the ones I performed are scientifically proven. How is that not an answer?
Well, so I guess to back up, first, there was a pretrial motion in this case to limit any testimony that there's scientific validity to the FSEs. So I think this is simply a gratuitous way for the witness to blurt out that these are scientifically proven, knowing that Florida law is clear that you cannot tell the jury that. You can tell the jury from a lay standpoint that someone has taken field sobriety exercises and they have not passed them, or what your observations are about those exercises, but you cannot tell the jury that field sobriety exercises are scientifically proven.
When you ask the officer, why did you not do the other tests? What other answer could he have given?
I should have. I just decided I didn't want to. I gave these 3 instead, but to simply blurt out that they're scientifically right.
Well, no, I mean, I gave these 3 instead would be non-responsive to the question. So that's not an answer. But I guess an answer could have been, I should have, but that would have been the answer that your client wanted, not the only answer.
Well, what is not a permissible answer is that they're scientifically proven.
What was the permissible answer, counsel?
I should have, I guess. That's certainly an answer that could have been given.
So conceding the point, what other permissible answer is there?
I don't know. And that's not my answer to you. That could be his answer to the question. I don't know why I didn't perform others. I'm not aware of others. I'm not aware of the alphabet test, perhaps. There's many other answers that could have been given.
If
But
he was,
Didn't the trial judge specifically caution counsel not to open the door?
well, so if he had said, why did you give field sobriety exercises at all? They're not reliable, are they? That would open the door. I concede if that was the type of question that was asked, that would open the door, and that would be what the trial court cautioned defense counsel against. But to simply say, why didn't you give other non-intrusive exercises when she's complaining of leg pain? Number one, defense counsel can't be limited in his ability to try to argue his point to the jury. That doesn't open the door to
counsel,
this.
since when is a question an argument to the jury?
The point he's trying to make to the jury is that she was suffering
So
from...
are you suggesting that the question was rhetorical?
No, maybe he would have said, I should have done that. That would have been very favorable to my client. That certainly is a possible answer that could have been given. But what is not a permissible answer is that they're scientifically reliable, especially in light of the fact that this was specifically brought up pre-trial, and the defense brought out that Florida law does not allow the jury to hear that these are scientifically proven.
But then he
Well,
was
what they
actually
can't hear-
questioned about, questioned further about those tests, and he acknowledged that he really had no basis for saying that they were scientifically proven. So is there prejudice from it?
Yes. So, I mean, of course, at that point, defense counsel is going to do whatever he can to try to limit the damage that's been done by this gratuitous answer that's been given by the deputy. But you ask, is there prejudice? From a harmless error standpoint, obviously, the state would have to prove beyond a reasonable doubt that there's no possibility this error affected the verdict. It's a very high burden. So the fact that impairment was disputed at trial makes it so the state cannot meet its burden. And I cited to part of defense counsel's closing argument in my brief, but if you look at defense counsel's closing argument at trial, more than half of the closing argument went to she was not impaired, and half of that went to she did fine on the field sobriety exercises.
Counsel, given what appears to be a very effective cross-examination on this point, give me your argument without being conclusory. Your brief says it's not harmless, but it doesn't say why. And so tell me why. How did this, in your view, affect the verdict?
Whether or not she was impaired is an issue. The state focused on her performance on the field sobriety exercises in closing. The state actually played
Just
those.
because the evidence might be relevant, right? Just because improper testimony might be relevant to an issue in the case doesn't necessarily mean it's harmful.
But again, we need to apply the standard. The standard is there any possibility that this impacted the verdict? So again, I point to the state in closing actually played her performance on the field sobriety exercises. So this is an issue for the jury to decide. If the jury, even just one juror, in the back of his or her mind is thinking, oh, well, he testified that she didn't do well on those two, and he also testified that they're scientifically proven.
And he admitted on cross-examination that he had no basis for saying that, he had no knowledge of it. It was just something that he was
learned
told
in a seminar.
But he couldn't give any specifics. He had no personal knowledge. He conceded that.
So if
He couldn't name the studies.
If the judge had told the jury to disregard the answer, that's one thing. If the judge had told the jury that these are not scientifically proven, that's another thing. Maybe that would cure this error. But if simply because he said on cross-examination that he heard in some type of seminar that he went to that these are scientifically proven, did that somehow make this harmless? No. The jury is still left with the impression that he said that this is an 80% scientifically proven test.
Do you agree that counsel's cross-examination on this point was highly effective?
Do I think on this point, was it highly effective? No. It only further highlighted for the jury that we're talking about these are scientifically proven. He's trying to do his best to mitigate the error, but at that point, the bell had been rung, the cat was out of the bag. There's nothing else he could do. At that point, the judge had to strike the testimony.
So the cross-examination was effective, but you're saying nothing could have unrung the bell, and nothing could have solved it.
Something could have. He could have come back and said, I'm wrong. I'm looking back on this, I now realize that they're not scientifically proven. If he'd have said that, of course, that might have cured it. But
What about scientifically proven to do what? I mean, what the case law prohibits the witness from doing is saying there's a correlation between the exercise and impairment. These are scientifically proven to show signs of impairment. Maybe that's what he meant. This is just indicia of impairment that the FSEs are designed. They're not there to prove under the influence. It's just...
Jury
Proven to
is
show
left
indicia.
with the impression, based on his testimony, that the fact that she failed 2 of these, it's scientifically proven that she's impaired. That's what any reasonable juror would take from that testimony. That's exactly what defense counsel was trying to keep out. Her impairment is an issue in this case, and yet this deputy gratuitously is blurting out they're scientifically proven. That's an error. It's not harmless.
Scientifically proven to show signs of impairment.
Scientifically proven that she's impaired because she failed.
Well, he didn't say that.
He said,
Scientifically proven. I don't know what the 80% meant, but to show signs of impairment, that's,
well, even that is
Prejudicial.
impermissible under the Medor case. It's one thing to say that I've given these exercises, and it's my opinion that the person didn't do well on them, a lay opinion regarding the exercises. You cannot give scientific validity. That's the exact quote from Judge Pariente's opinion in Medor from the 4th DCA. You cannot give scientific validity to these exercises. I don't understand how anyone could reasonably say that when he says they're scientifically proven, we're not now giving scientific validity to the FSEs, the 2 that he specifically said she failed.
Counsel, is there, you said that one of the reasons why the answer was inappropriate was because of the motion in limine?
Yeah, well, certainly it's brought to everyone's attention at
Where was
pretrial.
that? Where at the time that the objection was made, was that specific argument preserved?
He said, I mean,
Or in the motion in limine?
page 294, Judge, I guess I would move to strike that as being unresponsive, calls for hearsay. You opened the door to it, so I'll deny your motion to strike.
So it didn't mention the motion in limine, right?
You know, Your Honor,
Yes or no? Did he mention?
I just read to you what it says.
The answer is no.
And I would submit to you that when there's been a motion limiting pretrial to prohibit a witness from telling the jury that there's scientific validity to FSEs, and then a witness blurts out that they're scientifically proven, an objection
Counsel, if
at
you
that
want to
stage.
rely on the motion in limine on appeal, shouldn't you give the trial court an opportunity to consider that when making its ruling?
I would think that would be stretching the contemporaneous objection rule or any other rule regarding objections too far. I think it's sufficient when you've objected pretrial, you've obtained a pretrial ruling from the judge, and the judge in essence he's giving his opinion consistent with his pretrial ruling. He's just wrong. He did say pretrial you could open the door to it, so the only question becomes, did this open the door to it? He's already agreed that yes, generally speaking, you cannot let the jury hear that FSEs are scientifically valid, and now it's being raised.
So you agree that despite the ruling on the motion in limine, counsel could theoretically have opened the door?
Certainly.
Okay.
Again,
So I'll go back to my question. In response to my question, how did counsel's question not open the door? You talked about the motion in limine. Let's not talk about the motion in limine because apparently that's not an answer to the question.
one of the only ways that I know of that would open the door to this testimony is if he said, why are you giving these FSEs? What possible basis do they have to establish anything? At that point, that potentially could open the door. There still could be some argument at that point about
Why is it not an answer? Why is it not a truthful answer from the officer that, hey, look, you're asking me why I did these tests? I did them because I think that they're scientifically proven.
There's lots of truthful answers that witnesses give during trials, but the law doesn't allow those answers. So
Unless the door is opened.
Well, right, but okay, so the question to whether the door is opened also takes into account whether, in fairness, this jury had to hear this particular answer. So when responding to the question, why didn't you give other less intrusive tests, the jury in no way had to hear that these particular tests are scientifically proven. He wasn't arguing that they were not. He was simply saying that they're not proper in this case because she's suffering from an ailment to her legs, and therefore you're requiring her to, for these...
Trial counsel could have argued that to the jury without asking this question.
Then he also has a right to ask the question, why didn't you give less intrusive FSEs?
If he asks the question, the witness has a right to answer it.
But it's not responsive to his question.
Okay, but I'm trying to get you to explain to me how it's not responsive.
Because he's not in any way asking, explain why you gave these because they're reliable or not. He's saying, why didn't you give other exercises that wouldn't require this particular person who's just been in an accident and complaining of numbness to go through some balancing exercise? She was given the touch your finger to your nose. That doesn't require her legs at all, and she did well on that one. But the only other two that would require her to use her legs, she's complaining about numbness in her legs. So he has every right to ask, why didn't you give other types of FSEs that are recognized, such as the alphabet test, that wouldn't require to use her legs?
What if
because
it said-
these are scientifically reliable? That's not a proper answer.
So you think that if the judge had instructed the jury to disregard it, that would have solved the problem, but the cross-examination in which he basically acknowledged he had no factual basis for that statement would not cure the problem?
He didn't say he had no factual basis. He said he learned it in a seminar. He didn't in any way disavow his statement that these are scientifically proven. So I think those are two very different things.
But he couldn't name a study, and he couldn't say specifically what the findings of those studies were.
The jury still left with the testimony that he says these are scientifically proven. So if you ask me if the judge had given a curative instruction, of course the law says that we presume the jurors follow curative instructions. There's an exception to those line of cases that when the bell has been rung and the error is so significant that you can't get around that. But and maybe we'd be arguing that if the judge, if the next request had been, okay, I'll strike the testimony, now I want a mistrial. We're not there because this judge didn't even strike the testimony. But
What about the fact that there's a lot of other evidence of impairment? There were witnesses who testified to slurred speech, the odor of alcohol, the heavy eyes. So there was a lot of other evidence of impairment. So if they're scientifically proven to establish impairment, like Judge Harris said, isn't that it's already been established through a lot of other evidence?
My best response is if you look at defense counsel's closing, again, he spent pages, at least 20 pages, talking about the slurred speech the witnesses are not consistent regarding that. The redness in the eyes, there's a lot of explanations for that. Defense counsel goes through every single one of those factors and says there's an alternative explanation that would show she was not impaired. This was a disputed issue at trial.
Driving the wrong way down the interstate. Is that evidence of impairment?
It could be, and it may not be. That's not per se evidence of impairment. There's many
She saw headlights coming her direction. She continued on. At least one car swerved over. So is that not evidence of impairment?
It could be, but it also could not be. You could have people driving the wrong way, getting in accidents that are not impaired at all. They simply didn't see the one-way, wrong-way sign, and you could still have some vehicular homicide charge based on that. It wouldn't necessarily be DUI manslaughter. So it's not per se that someone's driving down the road.
Before she hit the victim's car, at least one other vehicle had to swerve off the road to miss her.
Again, if you're saying that driving the wrong way on I-95 is per se evidence of impairment, I submit to you that's not the law, Your Honor.
But the jury certainly could consider that as evidence of impairment, correct?
Yeah, again, I come back to if defense counsel had said, we're not going to argue impairment, we're only going to argue whether or not she caused or contributed to the death, then I couldn't be arguing that the error wouldn't be harmless. But when defense counsel spends the majority of his closing, including putting on Ms. Barfield, who used to work at FDLE, to call into question whether or not this intoxilizer was actually working, impairment was a big issue in this case. And therefore, if a single juror came back with a guilty verdict based solely on his testimony that, oh, she failed that these two FSEs and they're actually scientifically proven, they can't meet their burden that this error didn't affect the verdict. Let me quickly address claim 3.
And you're into your rebuttal, just so you know.
I see that. Thank you, Your Honor. I'm going to take 40 seconds. I'm going to try to sit down at the 3-minute mark. Claim 3 involves whether or not the judge should have given the lesser instruction for DUI with serious bodily injury. The standard in Florida is clear. Does the information allege all the elements, and is there some evidence establishing those elements? In this case, that's...
What evidence would that have been based upon?
Most importantly, it would be Deputy Miller's testimony on page 197. When he was at the scene, the victim's injuries were not life-threatening. So if this jury felt that she suffered injuries, but they were not life-threatening injuries, and then something later happened at the hospital, and again, unfortunately, we're dealing with a victim who was 91 years old.
Which wouldn't be a defense, right?
It's not a defense, but nevertheless, if the jury believed that all this accident caused was serious bodily injury but not death, and this court in Morgan said that the standard for getting an instruction on a potential defense theory is there any evidence in the record to support it, and you have Deputy Miller specifically saying
that was hearsay from Deputy Miller, because Deputy Miller himself didn't say that. He said he was told that.
It's evidence that came in this case that was not objected to by the state, so it's certainly something that was introduced. So this jury got to hear that her injuries at the scene were non-life-threatening. I think the evidence from Dr. Patel when she arrived at the hospital was also consistent that she was not in a life-threatening situation. She only became critical after she arrived at the hospital. So again, if the standard is there any evidence that would support that? And that's the only prong we're arguing about. The state doesn't argue the first prong under this test that the information would have alleged these elements, then it's error not to give this. And I've cited to the second DCA case that was one step removed, and this would be, then that's per se reversible error. Let me reserve the rest of my time for rebuttal.
Thank you, counsel.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. Before
you get started into your presentation. Let me ask you a question that Mr. Uffman wasn't given a chance yet to address, and that's the failure by the state to list Dr. Patel as an expert witness. And did that prejudice the defense? Should the defense have been given a continuance?
Okay, so it's the Richardson violation. The trial court
Difference
held
between
a...
deposing this witness as a fact witness and as an expert, obviously, an expert that you know is going to testify and be the only witness to give cause of death. They weren't aware that the state was going to do that at the time they took the doctor's deposition. So
They were not aware of that, but they were certainly aware of the doctor. The doctor was listed as their witness 6 months earlier.
the fact witness, she was there.
Fact witness, she was there, and during her deposition, she testified to the cause of death. There was never any proffer of, gee, I wish we had a chance to talk to her about X. It was just, she wasn't listed, so you need to exclude her. They didn't say what additional time they would need or what they needed to explore on that issue or how that affected them at all. They just merely said, well, we would have deposed her differently. They didn't say how. This was their witness. She was listed as her witness. And 2 weeks earlier at the docket call, they discussed this witness at length. So she was not a surprise.
Shouldn't the state at that point have listed her as an expert? That would have given them 2 weeks to take an expert depo. if that's what they wanted to do.
Ideally, they would have put her name down, filled out the proper paperwork, but everybody knew that she had an opinion of cause of
Well, I
death.
mean,
She was the one who declared her dead.
The rule's not advisory, is it? I mean, it kind of, you shall.
The rule's not advisory. We should absolutely comply with
You did
it.
not.
But what happens on appeal is you look at whether or not there was prejudice to the defense from that failure to apply.
Well, that was my question to you.
Correspond to it. And there was absolutely no prejudice listed. They just said, well, they admitted they deposed her. They admitted they were aware of her 2 weeks before, and they talked about her at length. And they admitted that during the deposition, she testified that this was the victim's cause of death. So it's not like they were surprised that she had an opinion about that. She testified to that at the deposition. It's not like they didn't ask her about it.
There was another doctor that was going to give the cause of death, right?
The medical examiner was supposed
witness.
to testify and did not. But again, they weren't surprised that she had an opinion about the cause of death. They talked to her about it at the deposition. She was the doctor who declared the victim dead.
Right, but they
So-
were surprised that the ME is not the one to give the cause of death at trial.
True. But, does that mean that prejudiced them, that this witness came up and testified the same thing that she testified about at her deposition?
Does it?
No. It does not. They had a full Richardson hearing. The trial court was at that docket sounding, was well aware of all the discussions at the time. There wasn't any surprise here. And what the whole discovery process is to prevent the defense from being surprised. We don't do trial by ambush, and this really wasn't. It was a clerical error not listing her, and of course that shouldn't have happened. But the question on appeal is that it prejudiced the defense. And we would submit there's not a single thing that they said they would have liked to have talked to her about.
The defense was aware of the fact that she didn't have any face-to-face contact with the victim,
Right?
correct?
They did an extensive cross-examination about that.
So
yes.
they would have been preparing for her testimony with the understanding that she didn't have that contact and wouldn't be able to testify as to what the other doctors had observed about the victim.
Well,
Wouldn't that be true?
during the deposition, the deposition is not in the record, but during the deposition, they talked about her involvement in the case and that she was the hospitalist. And it sounds like she was kind of in charge of putting everybody together. But she was the one who declared the victim dead, and she was also the one who had the victim admitted into the hospital.
But didn't she have to be listed as an expert in order to be able to give that cause of death, since she never had any face-to-face contact with the victim? And she didn't personally treat the victim?
She testified as an expert at trial, yes. She gave her opinion, absolutely. The question on appeal is, were they surprised by anything she said? Were they prejudiced in any way by not having her listed in that manner? And given the circumstances here, since she was listed as a defense witness, since they talked about her 2 weeks earlier about docket sounding and didn't mention any problems with her not being listed, they didn't specify anything that they would have done additionally. They just said, well, she wasn't we deposed her differently because she was an expert. Well, what does that mean? State pointed out they asked her about the cause of death, so they knew she had an opinion about that. And you know, when you look at her cross-examination, it was an extensive cross-examination of this witness. There was no lack of preparation there, and that's what the focus is on appeal. It's not, did we technically comply with the rules? No, we did not. But the question is, was the defense prejudiced by that? And the trial court had an extensive hearing about that, as they're supposed to do, to make sure that that there's nothing they need to fix, and that's what the trial judge did here. So they would have to demonstrate an abuse of discretion in the court's finding that this was inadvertent and that there was no prejudice to the defense. And we would submit that there is no abuse of discretion here. Yes.
Do you agree that the officer's testimony that about certain tests being scientifically proven was improper?
Yes.
Okay.
But we would submit that don't ask them why they're doing something if you don't want to know the answer.
Well, sure. That the other issues are, but nevertheless, was the door opened and was it
Right,
was
exactly.
it harmless error?
Right.
What's your take on whether or not counsel opened the door? Your appellant's counsel says, look, it was an improper answer to the question.
They were pushing the officer as to why he didn't do these tests instead of the tests he chose. When you push like that, the officer's going to answer the question. The answer was, because these are the ones I've been told are scientifically proven. These are the ones we're told to do. When you ask them why you didn't do this one, well, because I did the ones that are scientifically proven. I think you're taking a big chance asking questions like that and pushing that direction.
But the officer didn't really say, oh, because those other ones aren't scientifically proven, right? I mean, it seems like it would have been a little bit more direct answer to the question had the officer said, oh, well, because the reason I didn't do those is because those aren't scientifically proven. Instead, he sort of focused on the ones he did do, and he said, these are scientifically proven.
Right.
Do you see a difference there?
No, not really. I think it's, two sides of the same coin. I mean, look, counsel didn't say, well, are these scientifically proven? He didn't open the door in that dramatic sense, but he said, why didn't you do these instead? These are better. Why'd you just arrest her after these? And he said, because these are the good ones, essentially.
The actual question that was asked was, and then you decided to arrest her.
Right,
So
and then he said
it
yes
wasn't
and
really
explained why.
responsive to that question, was it?
Well, it was responsive to the line of questioning. The whole line of, the gist of that portion of the cross-examination was, gee, what are you doing these for when there's so many better ones that wouldn't have been influenced by the fact that she was just in an accident? And his response was, because these are the ones that are scientifically proven. I think that opens the door. I also think that's clearly harmless on this record. I mean, the cross-examination was very well done, and, the guy backed way off of that and said, I don't know what the studies are. Defense counsel brought up studies. Are you familiar with these? No, never heard of those. I mean, he clearly came up with this because he heard it in passing somewhere. It wasn't emphasized, never mentioned again by either party. It's not like the state got up in closing and said, you should convict her because we have scientifically valid field sobriety exercises here. It was never argued by the state, never mentioned by either party again. Cross-examination was effective, and there was tons of other evidence of her impairment. They had the video of her performing these field sobriety exercises. They had other witnesses who uniformly described her as impaired. And let me mention that the breath test was 0.153 and 0.148. So those are pretty high values there for her blood alcohol content. And they're not challenging the breath test on appeal. That's some very good evidence of impairment right there. So we would submit that this passing reference to scientifically proven that was effectively diminished by defense counsel was not harmful error in this case. As far as the permissive lesser instruction, you have to have evidence. I know it's not much, but you do have to have some. And causation in DUI manslaughter cases is very broadly defined. You have to cause or contribute. So to overcome that, you need some kind of evidence of an intervening act that was the sole cause of death. And I know there's this hearsay. Somebody told me that it's non-life-threatening, which is why I didn't haul her to the hospital to do a blood draw. We did a breath test.
Well, and
that's how it came up.
But it's a little bit more than that, right? Because when she, according to what I read, when she got to the hospital, she was very much alert and seemed to be stable, right?
Right, but then they looked at what her injuries actually were. I mean, people with ravaging cancer can look perfectly fine. That doesn't mean that they're doing well. She was responsive and talked to them, and that's what she was like when she first got there. Then they looked at what her injuries were. And when you look at the description of the injuries, I mean, they were very severe. Multiple rib fractures, a punctured lung, massive internal bleeding, which was really the biggest problem. Dr. Patel said she was severely critical when she came in. They were going to transfer her to a different hospital, but they did not think she would survive that transfer. So instead, they took her into surgery at Dr. Patel's call, did a couple operations, and she couldn't survive. So the fact that she was speaking and not overtly, throwing up blood or something doesn't mean that she didn't have significant life-threatening injuries. There's just no evidence. They would have had to put on some evidence of an intervening cause to get that instruction, because it's caused or contributed is a very broad phrasing of how the legislature has defined this crime. In order to overcome that, when you have life-threatening injuries like that, they need to show that something else was the sole cause of death. And there's nothing even remotely about that in this record. It's just a passing reference to why we did a breath test instead of a blood test. From somebody told me they weren't life-threatening. She didn't look like she was going to succumb to her injuries at the scene. She was responsive at the hospital, but she had severe life-threatening injuries. There's no question. This was not a coincidence that she passed away after this accident. She passed away from the blunt force injuries. That's the testimony by Dr. Patel, and that's very clear. So we would submit there's not that scintilla of evidence to support that underlying permissive lesser-included instruction. So again, abuse of discretion standard, we would submit that the trial court certainly acted reasonably in not giving that in the absence of any evidence to support it. Those are the only issues the appellant covered. If the court has questions on the others, otherwise we would rely on our brief on that and ask you to affirm. Thank you.
Thank you, counsel.
May it please the court. I'll quickly address claim 4, the discovery issue, and I disagree with opposing counsel regarding the standard that would apply. I think the Florida appellate cases have been clear that it's a very high bar for the state to meet its burden when there has been a discovery violation, and clearly there was here. Dr. Patel was not listed as an expert witness. So
Explain the prejudice to us.
So as I can't do any better than what defense counsel argued in the motion for new trial, which is 457 and 458. I think it's two parts. The main thing being that they had deposed her, but they hadn't deposed her as if she was going to be the expert who was going to give the cause of death. And that became a huge issue in this case. It's part of issue 1 in the briefs. It's discussed extensively, and defense counsel, argued at that time she's not qualified to even give this opinion. Those are all issues that could have been addressed further had she been disclosed as an expert and had they had an opportunity to properly depose her as the person that's going to give the opinion regarding cause of death. And again, when you go to the very high standard, and this is from the DeBoard case.
You did ask her in the deposition about the cause
The
of death.
deposition is not part of the record, so let me be clear about that. I haven't read the deposition, and nor should anyone in this case. I don't know why opposing counsel is referring to it, but it's not part of the record. So it cannot be considered by this court. It certainly wasn't provided by the state below when this was being raised. So that's not something that can be considered at this stage as to whether or not this was harmful or not.
It's in the transcript that they talked about the fact that she had been deposed and she had been asked about that.
And defense counsel specifically argued that she was deposed as if she was a witness who was at the hospital, not as the expert who was going to give an opinion as to cause of death. And that's a significant difference. It would be in any case. I have 30 seconds left. Let me just quickly address the second claim. Counsel argues that it's harmless regarding the scientifically proven because no one ever said that in closing. But the state does focus on the field sobriety exercises in closing, and they focused on them extensively. So maybe if FSEs had never even been mentioned again, they could say it's harmless. But they played the FSEs for the jury during closing. So now, upon seeing them again and remembering that Deputy Miller said that they're scientifically proven, that's the error. I ask this court to reverse. Thank you.
Thank you, counsel.